welcome to the People's Law School. This is the third session. For those of you who were absent last week, I'm Laurence Springberg, your moderator for the series. Please remember that we are on a tight schedule. As we saw last week, the presenters are challenged to cover all of their great material in the time that they have allotted to them. If you have questions, write them neatly on the index cards. Hold them up for us to collect, and we will try to get to as many of them as possible. We will take a short break after the first two presentations, but we'll keep it brief at just 5 minutes. I would now like to introduce Kathleen England and Paul Padda. Kathleen England specializes in employment litigation on behalf of the employee and civil rights claims. She is a native of Boston, Massachusetts, and has lived in Las Vegas since 1978. Ms. England served on the Nevada Supreme Court's Gender Bias Task Force, was the first chair of the Las Vegas Ethics Review Board, and was the president of the State Bar of Nevada in 2009. She is a master of the Federal Inn of Court. Ms. England has served on the board of the National Conference of the Women's Bar Associations and has been a volunteer trainer for the Rape Crisis Shelter. And for the last 7 years, she has been selected by her peers as one of the best lawyers in America. Paul Padda is a first-generation American and was born in Ithaca, New York. He received a Juris Doctorate from the University of Illinois, a LLM in corporate and commercial law from the London School of Economics, and a master's in social anthropology from Oxford University. In 2004, Mr. Padda moved to Las Vegas to serve as an assistant United States attorney, where he litigated both civil and criminal cases. Following 16 years of significant legal experience with the U.S. Attorney's Office, Mr. Padda formed a law firm with his colleague, Ruth Cohn, that would assist individuals and businesses in vindicating their legal rights. Mr. Padda also serves as a legal advisor to the Southern Nevada Children First, a nonprofit organization dedicated to helping homeless youth. Please join me in welcoming Kathleen England and Paul Padda to the People's Law School for the presentation.
Thank you for that warm welcome and that introduction. It makes you feel tired when you hear that. Well, we're here today to talk to you about Nevada employment law. And Paul and I are we've got a lot to cover. As Larry said, we're going to try to get you all through it. We have handed out to you rather extensive materials. You really don't have to take any notes. Our PowerPoint presentation is going to follow that, so you really don't have to write anything down. We've given you all the statutory references and things like that, so you really don't have to look it up. And what we're going to try to do, going back and forth between the two of us, is to kind of give you the highlights of everything and not just replicate what's on that, either on the PowerPoint or what's in the materials. So with that, we'll get started. It's my job to kind of give you an overall concept of what Nevada employment law means. Employment law, there's two different kinds of law, and Paul and I both had to go to law school to figure this out. There is common law, which means it's decided by judges making decisions, issuing opinions. And then there's statutory law. So you're going to hear us talk about both kinds of law. Generally, when we say a statute, we mean an actual passed law, either by the legislature, either by the U.S. Congress, or by the Nevada legislature. So we're going to, what generally happens is the legal concepts generally arise. Generally, a law is passed that has something to do with them, and then judges and juries decide what those laws mean in the particular context, of a factual context. So that's what you're going to hear us talk about. Generally, I know some people were asking us questions before. Paul and I both give the good lawyer answer, which is the answer to everything is it depends. So with that in mind, let's begin. Overall, in Nevada, we have the concept, we start with the concept of every employment relationship is an employment at will. What does that mean? It means that you can be fired at any time or you can leave at any time. It means that that employment relationship between an employee and employer may be ended by either party at any time, with a few exceptions. And those exceptions are what are important. That employment relationship cannot be ended, however, for a reason that is illegal. And we're going to talk a lot about all those illegal reasons about why an employment relationship cannot be ended, or an employer, let's call it, an employer can't fire you for particular reasons. Now, you often hear people mention the fact that, oh, we're a right-to-work state. And I'd like to bring that concept to you and make you and hopefully share with you what that really means. Right-to-work state has nothing to do with our being an employment at will state. An employment at will state, as I've said, means that your employer does not have to have good cause, just cause, or any cause to fire you. You can be fired for any reason as long as it's not illegal. Right to work is a statute passed by the Nevada legislature, and what right to work means is that you cannot be compelled to join a union in order to get the job or to stay on the job. So that's all that right to work has to say. The overall concept that we're going to be talking about really is this concept of we're starting from the building block of every employment relationship in Nevada, unless there is a contract or something to the contrary, is an employment will. It means you can walk away whenever you want, or they can fire you for whenever you want. So now I'm going to turn to Paul, and we're going to start talking about, under Nevada law, the kinds of reasons why you can't be fired or can't be disciplined or discharged. Every single one of these things are in your materials, so don't worry about writing it down. Just, we hope you'll listen, and if you have any questions, as Larry said, please write them on a piece of paper. We'll collect them, and then we'll try to answer them at the end, but we do have a lot to cover. Paul.
Good evening, everyone. As Kathy mentioned, there are a number of things that are considered illegal under Nevada law. There's going to be some overlap with federal law. Let's start with the first one, serving on a jury or serving as a witness in an administrative or litigation type proceeding. Apart from the right to vote, I think there are few things more sacred to American society than serving on a jury. An employer cannot punish you because you serve on a jury or because you're called as a witness in a civil or criminal case. The general rule here is what you need to remember is that you are generally obligated to give your employer at least 1 day notice that you're going to be required to serve on a jury or that you're being called as a witness in some type of case. And that's prohibited under Nevada Revised Statute 6.190, which is in your materials.
And I think that you'll see in the materials, we're always calling it NRS. That's simply referring to a Nevada statute. NRS means Nevada Revised Statutes.
Correct.
And those are easily, if you actually want to see the actual statute, you can go to the Legislative Counsel Bureau. You can just Google Nevada laws. It will take you to Legislative Counsel Bureau. Those are the attorneys for the legislature. And all of the statutes, remember they're passed as statutes, all of the statutes are codified, and then you can look at them right there and you can see the actual language. And oftentimes in Nevada, the language is fairly straightforward and simple.
Yep. Are you going to touch on military duty?
Oh, yeah. I'm sorry. Then another reason your employer can't fire you is if you're serving in the military and go off, that would include the Nevada National Guard. We're going to talk a little bit later about the much larger federal law which protects those who are in the service of our country.
Yep. Voting. With respect to voting, again, a very sacred right. Everyone has the right to vote if you're a U.S. citizen. And you cannot be punished for exercising that right. Your employer has got to give you time off to go and to exercise that right. Again, there are specific rules that apply as far as the amount of time that you're required, depending on how far you are from the polling station. But again, a very sacred right and not something that you can be punished for as an employee. School conferences, court appearances concerning a child. If you are a parent, guardian, or a custodian of a child and you are called to school for a counseling session regarding your child, again, you cannot be punished for that. Subject to certain, you have to give your employer notice that you're called, you have a conference to attend, but otherwise you cannot be retaliated against or punished in your employment for exercising that right. Uniforms. Some jobs require employees to wear uniforms. Where that's the case under Nevada law, the employer is obligated to provide the employee with the uniform. And if there's a special type of cleaning process involved with the uniform beyond sort of just simply throwing it in the washer and dryer, then the employer is generally required to pay for that as well.
The next topic, where there is a specific statutory prohibition in Nevada is the requiring employees to take lie detectors tests. Now, once again, as in every statute or law that we're going to talk about, there are always exceptions. But in general, an employer in Nevada may not require an employee to take a lie detector test and may not discipline, or an applicant may not discipline an employee for refusing to do so. And when I talk about lie detector tests, I'm talking about any sort of truth-telling assessment. So that could be, a polygraph, it could be a voice stress testing, all of those kinds of things. There's a lot of regulations about it, and there are, as I've said, there's specific exceptions where an employer may require an employee as a condition of continued employment to take a lie detector. But in general, those are it's a very specific exception. The next one is misrepresentation about a job. We have there's a whole series of statutes that were passed in the 1940s, which are very somewhat employee protective. And you're going to see some of those that are still on the books, and they still make a great deal of sense. One of these is this Nevada revised statute that was passed, I believe, in the 1940s. And it makes it unlawful for an employer to solicit employees by misrepresenting the terms or conditions of a job, or the existence or non-existence of a labor strike. Similarly, another statute that was passed long ago is that a manager or a supervisor cannot extort a commission or fee from any employee that is in their supervision or management in order to keep the job. So that's pretty much, prohibiting extortion in a labor setting.
Turning to employment of minors, there's extensive statutory coverage regarding the employment of minors. What's important to remember here is that an employer cannot generally employ a minor for a purpose that would be prohibited by public policy, such as, for example, something that might be inherently injurious to the minor or something that would be immoral. Let's assume, for example, employing a minor to work in the adult entertainment industry, that would clearly be something that would be qualified as immoral. Asking a minor to work on a construction job, work site, that's something that would be inherently injurious to the minor and could potentially violate that statute. I won't go into all the details, a lot of the materials in your packet of materials. However, with respect to minors under the age of 16, the general rule is this: a minor cannot be required to work more than 8 hours a day or more than 48 hours per week. And where you have a minor under the age of 14, generally there's approval required by a judge to deal with employing a minor at that age. Turning to refusal to grant leave to pregnant employees. Pregnancy is considered a protected medical condition, just like a disability or a sickness. Everybody in this room understands the concept of sick leave. Well, if you're a woman and you're pregnant, the employer has to respect that, your right to take time off as a result of that pregnancy. Any attempt to terminate a woman's employment based on pregnancy would be actionable. This is an area that is also covered by federal law, because pregnancy, terminating someone based on pregnancy could also qualify as sex discrimination. Right to engage in politics. Under Nevada law, as an employee, you have a right to run for a political office. You have a right to attend political rallies. An employer who punishes you or terminates your employment based on your exercise of that right would also be liable under Nevada law. However, what I think it's important to remember here is that there are reasonable restrictions. For example, an employer can say, I don't want you proselytizing your political views in the workplace. So whatever your political views might be, advocating on behalf of one position or another, or telling people how they should vote, that's something that could violate the terms and conditions of one's employment.
Okay, on to the next slide, please. Thank you. Okay, so the next statute we'd like to talk about is the right to look at your employment records. As long as you've been employed by a particular employer for more than 60 days, and if you get fired or you leave, you got to ask for this within 60 days. But you have the right to inspect your employment records, you have the right, your personnel file, all of your employment records, and you have the right to have a copy of them. So you can inspect the originals. You have the right to have a copy. Your employer, within certain limits, can charge you for that copy. Sometimes I've seen outrageous amounts charged to me as somebody's employer, but as someone's attorney. But in general, you have the right to look at those. Now, there are certain exceptions. Remember, I told you every Nevada law has exceptions. There are particular exceptions which employers often invoke when they've conducted confidential investigation. They say you can't have that part of the file. But this is very, very, and a very important statutory right that you have to look at your employment records. I always indicate to people that you should, if you're going to do that, you should invoke that in writing, so so that there's a record that you've asked for your records. I told you that there are always exceptions. In Nevada, we always have unique Nevada exceptions. The confidential reports is an exception. There's also another exception called a spotters. This is from the 1940s and 1950s. This was spotters were the kinds of people that detected gaming cheats. So there's always the Nevada exception, and your employer does not have to give you that kind of those reports.
Okay. Treatment of alcohol and drug abuse, here's a pretty straightforward one. If your employer provides you with health care benefits, they also have to provide you with the benefit of receiving treatment if you have an alcohol or drug condition. So that's pretty straightforward. That's under Nevada law. Genetic testing, this is another area where as a term and condition of your employment, you cannot be forced to undergo genetic testing, even if you're a prospective employee. So a good example of this would be, for example, let's say a health club asked all of their personal trainers to undergo genetic testing to determine if they had a gene for obesity or something like that. And they would fire people because of that. That would clearly violate Nevada law. In addition, there's also a federal statute, which we're going to talk about later, but that would cover that as well.
The next most important, very important Nevada law is the one I'd like to talk about, which is once again one of those old statutes, but has some unintended and modern consequences, and it is the statute called blacklisting. It's prohibited that an employer blacklist an employee, meaning that's obviously an old derogatory, now sort of racist term, quite frankly. But what it means is that an employer is not supposed to be trashing an employee and preventing them from getting another job. There are qualified exceptions to this. The Nevada Supreme Court decided that it's okay for employers to say certain things about ex-employees, and so I would caution the use of that is very, the legal standing of it is very uncertain and, once again, fact-specific. But in this statute, which we cited in the materials, there isn't a unique feature in Nevada law that says that nothing prohibits an employer from giving an employee a truthful statement of the reasons for discharge. And an employer must furnish that statement if requested by the employee. It's a little-known statute. Most employers disobey it, but it once again may if you're trying to access your rights and understand what happened to you in the workplace, that may assist you.
On our PowerPoint, we have next topic as non-competes. However, in your packet of material, you'll note there's a pretty incredible statute here in Nevada which punishes an employer, in fact, imposes a $5,000 penalty for any employer that attempts to obstruct an employee's right to obtain employment elsewhere. And there's a good public policy reason for that. You know, the legislature wants people to be able to freely move between jobs. However, parties have a right to contract with one another. So if an employer says to an employee, one of the conditions of this employment is going to be that if you leave, there's an enforceable non-compete, and the employee accepts that by entering into a written contract, the employer can seek to enforce that in a court of law, and courts have upheld those non-competes. So that's important to remember. If you sign a non-compete, generally speaking, you're going to be held and you're going to be bound by that.
Similarly, on that non-compete, those are enforceable. I can't tell you how many people call my office and where they've left one employer, they've gone to the employer's competitor, and they've been told by their brother-in-law or other people in the workplace, oh, those are not enforceable. They are. And they're enforceable by courts, usually under a temporary restraining order, a preliminary injunction, and they are enforceable if they're reasonable as to time and scope. And generally 1 to 2 years, that means you're going to sit out 1 to 2 years. So I would caution everyone to very, very carefully look at all these documents that you're signing when you're in the euphoria of just having gotten this job, and see whether you're signing a non-compete, which is supposed to protect the confidential and trade secret information of the employer, but is often used to bind an employee at below standard wages to a particular employer. I once had a huge case that dealt with non-competes, and the supposed confidential information was the shape of a swimming pool. Wow. And I said, okay, there's two shapes of swimming pools in Las Vegas, right? Kidney-shaped and rectangle. Okay, what's the big secret? And yet thousands and thousands and thousands of dollars later, we had a preliminary injunction, and my client was not allowed to go to the competing swimming pool company because he knew the shape of pools that had been built by his former employer. So just watch those kinds of things.
But I think that highlights a really important point, and that is a point that you made earlier, Kathy. For every rule, there's always 5 exceptions. I think if you're confronted with a contract that contains a non-compete, consult with an attorney.
Or cross it out.
Or cross it out.
Help them sign it. Right. Same with an arbitration clause. You're going to see a lot of mandatory arbitration clauses, which requires you to give up your rights to file lawsuits, which requires you to give up your right to a jury trial if you've been discriminated against, which requires you to give up all of your rights in the workplace. Those are enforceable and will be enforced in Nevada, and they're, quite frankly, I'm a plaintiff's lawyer. I think they're unfair. I think they're horrific, and I would love to see people just cross them out and say no. But I understand that if you'll often see them on job applications. You haven't even gotten the job yet, and the employer is asking you to enter into an arbitration agreement. These are really things that need to be addressed, I would suggest, by the legislature, because I think that people unwittingly enter into these contracts, which are later enforced against them. The next topic we wanted to talk about is unemployment compensation. Everyone, or every employer in Nevada, pays a certain amount of fees to unemployment. If you lose your job for any reason other than gross misconduct, you are eligible for unemployment. If you voluntarily leave your job without good cause, you are disqualified from getting unemployment. And if you are fired for gross misconduct, which there's a whole series of cases about what constitutes gross misconduct, you also are ineligible for unemployment. Similarly, there's a great website that the Nevada Employment Security Division has. You can go there and find all the rules. I'd like to just quickly get through some of the wage and hour stuff so that you understand this a little bit and how it interacts with the federal law. There are two sets of wage and hour laws. There's the state wage and hour law, and then there's the federal wage and hour law, which is called the Fair Labor Standards Act, FLSA. They have two different standards, although there is some overlap. In general, in Nevada, under Nevada law, the wage and hour and the requirement to pay time and a half for overtime under Nevada law only applies to people who are making 1.5 times the minimum wage or less. The federal statute is different. That applies to everyone, and they have different standards. Nevada law is going to apply if you have to work more than 8 hours in one day. Federal law is going to apply if you're being required to work more than 40 hours in a week. Both of them are very, very complex statutes. We're not going to go into them, but I can tell you the Nevada law is enforced by the Nevada Labor Commissioner. The Nevada Labor Commissioner has an excellent website. We've given you the website and the materials. Go there, look at it, understand it. If you've got any questions, they actually have an interactive website where you can ask questions. The federal law, on the other hand, is enforced by the U.S. Department of Labor. We've given you that website as well, and there's lots of really great materials answering a lot of questions. Both are very highly complex statutes, and they require rest periods, meal periods. There's lots of litigation about what's called donning and doffing time and all this kind of stuff. So I would commend those websites to you, because I think that they could far better answer your questions, certainly, than I can. There's one more thing I wanted to cover under Nevada law, which is the payment of wages. Once again, hearkening back to the 1940s, we passed a bunch of laws back there that requires employers that at a minimum they must pay you 2 times a month. They also must pay you in cash. This was as opposed to script from mining companies that you could only spend in the mining store. They do have to pay you in cash or by check. It's got to be some kind of legal tender, all right? But the most important thing that we have today, now your employer can bargain that away with you and you can agree to get paid once a month. But in general, it's got to be twice a month. But more importantly is, when do you have to be paid if you're fired or you leave? All right, if you are fired, Nevada law requires you to be paid immediately. The statute we've given you doesn't tell you what immediate is. You have to go to 3 more statutes to figure out what that is. But if you're fired, remember, if you're fired, you've got to be paid immediately, and that's about 3 days, probably 3 business days. If you're not paid immediately under the statute, then there are certain penalties attached, which is your wages continue for 30 days until paid, whichever's first. Now, if you quit, that's different. The employer must pay you within 7 days or at the next pay date, whichever's first. So there are 2 different requirements. And once again, those penalties attach if the employer does not pay you on time. Those are very specific statutes. We've given you the references. You can go and look at the statutes themselves if you'd like. And I think Paul's going to finish up with our Nevada statutes on safety.
Workers' compensation, everyone understands what that concept is. It's different from personal injury. If you're involved in a car accident, people are familiar that you would sue the other driver if they were at fault. In workers' compensation, if you are injured on the job, you cannot sue your employer for that personal injury. You have to go through the workers' compensation system. And that's why every Nevada employer is required to pay into the workers' compensation system for that very purpose, because that system in part protects them from lawsuits, but it also governs what your rights are as an injured employee. If you're subject to a hostile work environment, or your employer is doing something that, let's say, you feel violates your rights, be careful what you say in the workplace. This is an area where words have consequences. Under Nevada law, a threatening statement can allow an employer to get a restraining order against an employee up to 15 days and even up to a year, depending on the nature of the threat. So if comments or statements you make could be interpreted as threatening to the employer or other fellow employees, the employer can take some legal action requiring you to be barred from anywhere near the place of employment.
And actually, the statute that Paul has just talked about, a Nevada statute, was passed quite some time ago, and it actually was as a result of victims of domestic violence whose either partners or spouses or whatever were coming to their workplace and threatening them there. And we passed a law in Nevada that allows an employer to go get a temporary protective order to ban that abusive spouse, whatever, from coming into the workplace and threatening that employee. It's a pretty it's an amazing statute that we did pass. Last but not least, of course, my personal favorite is that we do have a law in Nevada that requires an employer to allow a certified service animal to accompany a disabled person anywhere in the workplace. And that's as a result of that statute came about as a result of a case which had to do with the training of guide dogs in the Clark County School District. And the Clark County School District spent over $500,000 trying to keep a golden retriever out of a music teacher's class. I'm pleased to say unsuccessfully.
And Kathy, a service animal does not necessarily mean just a dog, correct?
That's right. It could be any certified service animal, and there are many other kinds of animals that that provide service to disabled people, and their right to be in the workplace along with their owner is protected by Nevada statutes. So now we'd like to turn a little bit to the part of the law that Paul and I are far more familiar with than all those little statutes, which is discrimination. Both Paul and I represent many, many, many victims of discrimination, and we'd like to talk about those laws a little bit. I'm going to start with the Nevada law. We have a Nevada law which is going to sound exactly like the federal law in certain respects that Paul is going to talk about. But that is the Nevada law which says, Paul, thank you. This is the Nevada law which prohibits discrimination. And I've kind of paraphrased it to you. And it's very, very similar in certain ways with the federal law, which Paul is going to talk about, which you see down there. The famous federal law is Title VII of the 1964 Civil Rights Act. But our Nevada law was passed in 1965, the year after the federal law. And basically what it says is that for every employer of 15 or more employees in any 20 consecutive weeks in this year or last year, and remember, we fight about that with employers who think they don't have enough to qualify. But it is unlawful for an employer, and that would include an employment agency, labor organization, or employer to refuse to hire, to fire, or to otherwise discriminate against any person with respect to that person's compensation, terms or conditions or privileges of employment because of these reasons. And now you're going to see it. The first one is race. The second one is color, religion, sex. Now, this is something that's in the state statute that is not in the federal statute, sexual orientation. And now here's another reason that's in the state statute, but not in the federal statute, is gender identity or expression. That is for people who are undergoing, that's for transsexual, to the protection of those individuals in the workplace. Age, you're going to see that in the federal statute, disability or national origin. So since 1965, with the exception of sexual orientation, gender identity, age, and disability, it has been unlawful in Nevada to discriminate on the basis of race, color, religion, sex, and national origin. I know some people in this room will remember long ago when you opened the want ads in the newspaper and it had female positions and male positions. That was ostensibly outlawed under the federal statute in 1964, and then under the state statute in 1965. So we're going to talk a lot about discrimination. This is as simple as it is, and this is where the battleground that we face every day. And we're going to talk a lot about the body of laws that have arisen as a result of case law, which is interpreting these two very simple statutes.
That's right. Title VII of 1964 Civil Rights Act, that is the landmark federal legislation basically announcing people's civil rights in the workplace. And as Kathy mentioned, here what it does is it prohibits unlawful discrimination based on color, religion, sex, national origin. This is a law that was amended in 1991. There were some important amendments. For example, the amendments allowed individuals to have the access to a jury trial, as well as punitive damages, as well as damages for things like emotional distress. So that was a very important amendment. What's not listed on our PowerPoint is protected activity. If you are engaged in doing some act that the law allows you to engage in, and your employer punishes you, that would also be prohibited under Title VII of the 1964 Civil Rights Act. So let me give you a good example. Let's assume you're injured on the job. You have the right under state law to file for workers' comp. And as a result of that, your employer gets upset and says, you know what, I'm going to fire this person because they filed a workers' comp claim. That would be actionable under Title VII because you've engaged in protected activity. State law allows you to file that claim, you've exercised your right, and now you're being punished for it. So that's an important fact.
So the part of the discrimination law, which I apparently deal with most, but which we usually get most of the questions in these settings about, is sexual harassment. And so we thought we'd just digress a little bit to explain to you exactly what is sexual harassment. You know, it's always been in the news. It's been in the news most frequently. And let me explain to you, like when I went to law school and took employment discrimination, there was no such thing as sexual harassment. It was not yet recognized as a form of sex discrimination. In fact, it was recognized first by a federal court in 1978, which is the year I graduated from law school. There's no cause and effect relationship there. But be that as it may, sexual harassment in 1980, and let me give you a little context. In 1980, Clarence Thomas was head of the EEOC, the U.S. Equal Employment Opportunity Commission. So he was head of the agency which promulgated this definition of sexual harassment. One would hope that he might have been a bit more familiar with it, since he was head of the agency that came up with the definition and recognized that sexual harassment, meaning requiring somebody to engage in unwelcome sexual activity or to submit to sexual advances in order to keep their job, is a form of illegal sex discrimination. And this is what the this is what the regulations that were promulgated, that were set out by the EEOC. And I mean, I could actually say this by heart. This always goes up on a jury instruction in every sexual harassment case. And of course, many of you have worked for employers that have this definition. But the problem is that who can understand what the definition means? What it really says is that their unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of sexual nature constitute sexual blah, 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 blah. When submission to such conduct is either explicitly or implicitly made a term or condition of the individual's employment. Okay, that one's easy. That's what we would call the quid pro quo. You know, we lawyers love to talk in Latin. Quid pro quo, sleep with me or I don't get the job. Concept never heard of in Las Vegas, huh? So now the second one's more important. Submission to or rejection of such conduct is used to make decisions, which is if the person didn't sleep with the person who said sleep with me, don't get the job, then it's used against them. So you don't submit to the sexual advances, so you get what? The graveyard shift. You used to work days. Now you get the graveyard shift. Now you get put somewhere else. Those are very important concepts. The third one is the hostile environment, and that's where the huge battleground really comes. And I want you to just share and read with me what it says up there. And this is the definition. Remember I said unwelcome sexual advances. The linchpin is that it's unwelcome. It doesn't matter, for example, the first case, Meritor Savings Bank, Meritor versus Vincent versus Meritor Savings Bank, decided 1986 by the US Supreme Court. Michelle Vincent said that she had sex with a bank vice president 40 to 50 times. She never claimed rape. She sometimes did it at the bank vault with him. And what was her reason for doing that? She said, I thought I'd lose my job. I'm a single mom, raising 2 kids, I've got health benefits, I pretty much would have done anything. And the US Supreme Court held that economic coercion, it was unwelcome. It's not the test of rape, it's whether the conduct is unwelcome. Did the victim want to do whatever she was forced to engage in? And it can be a him too, but if the victim is, and we have a reasonable victim standard, would a reasonable victim in that person's position find that conduct offensive? Read with me. Such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. That is the simple definition. And remember it says has the purpose or effect. That means it's not a good defense to say, oh, I was just kidding when I made her do that or when I said that. And remember, there is a rule of reason. I know people are really skeptical, like anybody, tell one stupid joke in the workplace and oh my God, it's sexual harassment. It's not. Neither Paul nor I sue any employer for one stupid joke, all right? What we sue for on behalf of our clients is because somebody has been subjected to degrading, humiliating behavior which has had the purpose or effect of interfering with that person's ability to do the job. Generally, it has to be severe or pervasive, not both. One rape's probably enough, because that's the high level of severity. Pervasive, if it's not a rape, let's say it's a joke. If it's a joke and it's a bad joke, or it's intimidating someone by standing too close to them, by looking down, by leering at them, by using offensive words in the presence of, and it's just like racial harassment, using sexually derogatory terms. Some of them I can't say on TV, I guess, because when I give this lecture, when we're talking to managers, we're talking about the kind of language. If you're a manager or a supervisor and you are using language which your subordinate employees find offensive in any way, shape, or form, do you think that inspires them to be a better employee? Of course it doesn't. What it does is it materially interferes with their ability to do the job, meaning it A, ought to stop, and B, the employer is going to be liable for the sexual or racial harassment. Racial harassment is exactly the same thing, and I often say if you want to understand how offensive it can be to that victim, all you have to do is change the sexual harassment or the sexually connotated, the sexually derogatory terms, turn them into racial derogatory terms, and then tell me if that's okay in the American workplace. And generally, we would all agree it probably isn't.
So Kathy, I have a question for you. People often think of sexual harassment as some type of conduct which victimizes women. Is that true only?
Not necessarily. I mean, it depends. No, men can be victims of sexual harassment just as well as women. Sexual harassment has very little to do about sex. It has everything to do about the abuse of power. And the abuse of power, we have a couple of U.S. Supreme Court cases. One of them is Onkal, which was a case decided, it was a bunch of oil rig platform workers, and you can have homosexual sexual harassment, you can have heterosexual sexual harassment. The point is that the conduct, the offensive conduct, A, is unwelcome, B, is severe or pervasive, and it's directed at that victim because of the victim's gender. So you're making fun of the person for, no, making fun is not a good word. You are ridiculing, debasing, and humiliating somebody,
yeah.
All right, because of their gender. And under Nevada law, which we looked at before, that can also be because of their gender orientation, meaning if they're homosexual, or it also can be because of their gender expression. If you're making fun of effeminate men in that way, there's a Ninth Circuit case, Renee versus MGM Grant, where a room service waiter who was male was being sexually harassed in the sense if he was being made fun of that he wasn't, quote unquote, manly enough. So he was being tortured by his fellow employees because he wasn't manly enough. That was held to be a form of sexual harassment because it was being directed at him, not that they wanted to engage in sex with him, but that they were making fun of him because he did not fit their stereotype of how men should act. Similarly, that it transcends all those kinds of things. What Title VII really does, and all the other statutes we're going to get to and talk to about now, these laws, what are you saying? 5 minutes? Speed it up. Okay, these laws require employees to be judged by the content of their job performance, and not because they look like somebody, or not because they have immutable characteristics of birth, and not because they have dark or light skin, or frizzy hair, or the church that they go to on Sunday, or the synagogue that they go to on Friday, or the no church that they go to. These laws all embody our concept for the last, 45 years, that employees should be judged by what work that they do, not because of what they look like or anything about them that has nothing really to do with their job performance. So now we're going to run through all the other federal statutes, which are very similar, and often adopt the Title VII.
The Age Discrimination in Employment Act, commonly referred to as ADEA. You've heard the phrase, age is just a number. Well, Congress determined what the number is to qualify as being old. 40 years old allows you to file potentially an age discrimination claim. So if you're below the age of 40, what's important to remember, you can't allege age discrimination. But any employment action that discriminates against an employee on the basis of age, we want to hire a younger worker, you're just too old for this job, that sort of thing, could potentially qualify as a claim under the ADEA.
Similarly, we've got the Americans with Disabilities Act. That's the federal statute. It's very similar to the Nevada statute. That requires employers to accommodate employees with disabilities. A disability is the substantial impairment of one or more major life functions, and an employer has to look at that, has to look at the capabilities of an employee, and not the incapability. An employer is required to offer reasonable accommodations that would allow the qualified disabled employee to perform the essential job functions. That's all it means. It's very straightforward and very simple. I'm supposed to talk about the Lilly Ledbetter Act. That was the one that was the first statute signed by President Obama. It overturned a U.S. Supreme Court case that had been decided the 2 years before. Lilly Ledbetter worked for Goodyear Tire. She discovered when she retired that for 25 years she had been paid less than male managers. So she sued. The U.S. Supreme Court dismissed her case, overturning years and years and years of case precedent, saying that she should have filed the first time she got a paycheck, 25 years before that, which she didn't know about, because she got the anonymous list of what everybody was paid and did not know it for 25 years. She should have filed it when she didn't know that she was being discriminated against. this statute overturned that U.S. Supreme Court case, and now every paycheck that embodies the discriminatory pay is a discrete act of discrimination, and the employee is now once again allowed to file on that basis.
The next two laws, Kathy talked about some of these earlier. They're state counterparts, but as the titles would imply, the first one, Genetic Information Non-Discrimination Act of 2008, commonly referred to as GINA, prohibits discrimination based on genetic testing or requiring an employee to undergo genetic testing. Similarly, the Employee Polygraph Protection Act of 1998, same sort of thing there. As the title would suggest, you cannot be forced to take a polygraph as a condition of employment. There's some others here. Uniform Services Employment and Re-Employment Rights Act, that's a mouthful, USERRA. You cannot be punished for either serving in the military as let's say, a reservist, or being called up for reserve duty. Your employer can't punish you if you're complying with your military obligations.
That's a hugely, hugely, hugely important federal act. It also, when a service member comes home and gets his or her job back, they cannot be fired for cause for a year. So it adds that added element in addition to protecting their actual job. The Equal Pay Act is very similar to Title VII. It's the same thing. It requires women to be paid the same as men for equal work. And then the WARN Act is the Workers' Adjustment and Retraining. That's when, and you've seen some of this in the newspaper recently, the WARN Act requires an employer, provided they fit certain criteria, to give 60 days notice of shutting down a plant or a business. We wanted to tell you, let's see, what's the next one? Oh, the Fair Labor Standards Act. We talked a little bit about that. Once again, this is now the federal corollary to the state statute of minimum wage, what has to be paid, when it has to be paid, how it has to be paid, and then all the exemptions that employers get out of not paying time and a half after a 40-hour regular work week.
The National Labor Relations Act, in a nutshell, what this law does is it protects you if you engage in union activity, for example, collective bargaining, being a member of a union, or being asked to join a union. Your employer can't punish you for that.
Family and Medical Leave Act, that's another, that requires an employer, so long as you fit the criteria, which means you have to have been employed there X number of days, and it only applies to employers of 50 or more employees. Family and Medical Leave Act requires your employer to allow you 12 weeks. This is maternity and paternity leave. This is allows you must be allowed to take 12 weeks, up to 12 weeks of unpaid leave. You can also do it intermittently, and you can do it, it's triggered, and you can access it for the birth or adoption of a child, or the care of a seriously ill family member, or your own illness. So it's a big statute. It's enforced both by the Nevada Equal Rights Commission and by the EEOC. And that leads us to the next, oh, not that one, sorry. I didn't put this up, sorry. I put together the PowerPoint, this is my fault. What we wanted to tell you, all these discrimination statutes that we were telling you about, both the state statute and the federal statute, this stuff is in your materials, and it's on page 6 if you're following along. In order to pursue a lawsuit based on discrimination, you have to file with the administrative agencies. And you've got to let your stuff sit there for a minimum of 180 days. Then you can ask for your right to sue letter, and then you can go file a lawsuit. But there are two agencies, we've given them to you, the Nevada Equal Rights Commission and the U.S. Equal Employment Opportunity Commission. They both have websites, they both have intake forms, and they both have a lot of information that you can access. But please keep that in mind.
And I think, touching on what Kathy said, one of the most important points to remember is if you believe you've been subjected to some type of unlawful employment action, what's critical to remember is you have 6 months to contact either the Nevada Employment Rights Commission or the Equal Employment Opportunity Commission. That's very critical. There are exceptions to that rule. Sometimes it can be extended up to 300 days, but as a general rule, keep that in mind, 180 days. All right.
You ready for some questions, Kathy and Paul?
Well, you're reading that. No, well, we just want to, this is the thinking outside the box. We were going to run through these for you, but they are in your materials, and we've given a little description. In addition to those statutory claims, okay, when you file a lawsuit under Title VII or under the Nevada Fair Employment Practices Act, oftentimes, for example, in sexual harassment cases, oftentimes there are torts, physical civil wrongs that you can also append or add to your lawsuit. And that's what we're saying here. It used to be in Title VII until 1991. We didn't get jury trials, we didn't get compensatory damages, we didn't get punitive damages. So we'd always have a couple state tort claims in the appropriate circumstance. And so these are the kinds of torts and quasi-contractual things that we often, in addition to suing just for discrimination under the statute, we will also add these in the right circumstance. An assault is the apprehension of an imminent battery. A battery is an unconsented to touching. You've got intentional infliction of emotional distress, breach of contract, and all invasion of privacy. That's often one, where somebody's looked in somebody's personnel file and found certain things, or the sexual harasser is calling his victim at her home and leaving messages, or doing drive-bys, or doing all the kinds of creepy things that unfortunately sexual predators do, and sometimes they're in the workplace and they're making their fellow employees or their subordinate employees the victims of that. So we've put those all in here for you. We've given you a little explanation in the materials, and with that, I guess we're ready to answer some questions.
Can an employer terminate an employee while the employee is on medical leave due to an on-the-job injury, and if so, are there any consequences?
It depends. It depends. I mean, somebody has it's a great question. And the reason I say it depends is because there are certain protections under our workers' comp statute, and then there are certain protections under the Americans with Disabilities Act, and then there are certain protections in the intersections of those. And there is never one answer to that question. And the answer, the question says can, an employer can always do it. It doesn't mean it's right, and it doesn't mean there isn't a consequence to it. So I can't really answer that question.
But I think
it's going to be real fact specific.
Exactly. That was what I was going to follow up on. The facts always matter here, and so if the facts support the employee being on workers' comp or exercising their rights under FMLA, and there's retaliation as a result of that, potentially that is clearly discriminatory and actionable.
Okay. Some employees at the casino where I work are required to maintain a media profile. Has Nevada had experience regarding employment law and Facebook, MySpace, and other social media?
That's a great question, and it's one that's coming up a lot, and we're seeing a lot in the battles that we're doing, where my clients, as the suing plaintiff, is being asked to provide their Facebook account and their Facebook password and all of their postings to Facebook. I can tell you that there's probably no employer that doesn't go in and look to the extent they can, look at what is out in the public range. And that internet has given us a much broader world of what's out there in public. And as some people are now learning to their eternal disappointment, internet means forever. It never goes away. So yes, but there are some protected aspects. We've got some case law coming down where employees were engaging in under the NLRB, protected conduct on Facebook. They were banding together to talk about working conditions, and they were then terminated. Their employment was terminated for engaging in that protected activity, and that was found by the NLRB to violate the NLRA, that they were engaging in protected conduct. So yes, it can be protected conduct. It may not be, and there's a wide variety. It depends on how it's being used. There's also this invasion of privacy. There's been a firestorm recently back east where employers were requiring people to give over their Facebook password as a condition of employment. And people were saying, no, that's private. And I caution people, just make sure all your privacy settings are on so you can say, no, this was private, it's only for family and friends, and no, I'm not going to give it to you. So, it's all of these cases are going to start winding their way through the justice system. And I can tell you in federal court, maybe with one exception, I don't think any of our federal judges, perhaps with one exception, Judge Gloria Navarro, who is all electronic, they might not quite understand what we're talking about when we're talking about Twitter, tweeting and Facebook and all the social media. So I say that too to my clients, on my client information form now. I ask, and I will go to my client's Facebook, all right, and I will look at what my client has said and what they've posted. And it's not, I want to see what they've put on, what they've put up there, and what other people have had access to.
I think a good follow-up on that point also is that many people don't have a written contract per se, but take a look at the employee handbook that your employer might have, because there may be standards governing your conduct. So, for example, if you're putting something on the internet that may cause people to look at what you do for a living in a bad light, or it's contrary to your position that you occupy at the casino or whatever other place of employment, they might be able to get you that way. The employer might say, look, you're doing things and putting things on the internet that really undermine your position, and it's governed by your employee handbook.
All right. And we have time for one last question. What are the legal ramifications for an employer to classify you as a part-time employee, only receiving part-time benefits and pay, yet schedule to work a full-time 40-hour-a-week schedule?
That's labor law.
It depends. It depends on what we're talking about and what it is that what it is that you're asking. You're saying that, does the employer have a contract for health care benefits that says that all active employees who work a minimum of 32 hours, because I want to get over the hump of the 30 hours, works a minimum of 32, are eligible for health care benefits. So a lot of it's going to depend on why they're failing to give a particular benefit that somebody might think they're entitled to as a full-time employee, and that there needs to be a little bit more of a drill down. And I'm not sure I can really answer that question. But there are certain benefits that you might be entitled to, especially, for example, and a lot of it's going to depend on what contract has the employer entered into with the healthcare provider, and what have been the limitations. Has the employer decided that everyone's going to get health care or everyone's going to get pension benefits? I can tell you, for example, Starbucks. Starbucks has a 401k for its part-time employees. They have lowered that. They decided that that was important. They've got 18-year-olds who just work there part-time, and they're part of their 401k. So the employer is entering into contracts of which the employee is a third-party beneficiary, so it's going to be governed by that contract. But it's a tough question, and if the employer is kind of using this as a subterfuge to refuse to give benefits, like not allowing that employee to be part of the 401k plan or not providing them benefits, then I would caution that the employee really needs to keep track of their hours so they can prove how full-time they are. And just in case you didn't know, the Department of Labor has a really good app for your iPhone that allows you to keep your hours on your phone. So just an FYI for those of you who do that.
And that brings up another good point. While that may not be discrimination, that's certainly a violation potentially of labor law. So your remedy may not be before the EEOC, but in fact before the Nevada Labor Commission, and you can file a grievance with them.
Or the U.S. Department of Labor.
Correct.
Yep.
All right, well, thank you, Paul and Kathy. On behalf of the Nevada Foundation for Consumer Education, I'd like to provide you with these certificates of appreciation.
Thank you
both.
Thanks, everybody.
I'd like to introduce our next speaker now. Gerald Welt received his Juris Doctorate from California Western School of Law in San Diego, California, and has been in the practice of law since 1973. He practices workers' compensation and Social Security disability law. He has served on the Nevada Justice Association's Board of Governors since 1979 and is very active in the State Bar of Nevada as a member of both the Professionalism Committee and the Lawyers Referral and Information Services Committee. Gerald is a member and past state chairman of Nevada Organization of Social Security Claimant Representatives and was named as a colleague of the Nevada Law Foundation. He has volunteered in a variety of capacities for numerous charitable and nonprofit organizations. Please help me in welcoming Gerald Welt.
That's very impressive. It has nothing to do with what I'm going to tell you, so hopefully it will go offline momentarily. I'm talking about Social Security disability, as you know. Sort of interesting sandwich between these two presentations. The one you've just heard obviously has to do with your employment, your relationship with your employer, your relationship after you leave employment. The one following me is to do with workers' comp, what happens if you're injured on the job. What I'm going to talk to you about is a complete absence of employment. And that's really the test for Social Security disability. You will have heard a number of rumors, and your friends and your brother-in-law will tell you how the system works and who got benefits and who doesn't. But let me try to clear up some of that initially. One, you have to be seriously injured. You have to be sick. The process, and I'll explain how we get there, could take 2 to 3 years here. It could take 5 years in other jurisdictions. So all my clients are sick or ill. Now, they may not be sick or ill enough for the Social Security Administration through their regulations and rules, but these people are sick and they're injured. And it would be very rare that anyone would be able to gam the system and get on Social Security without having a severe problem. The reason being, you have to prove Social Security disability by objective medical evidence. You just can't walk in there and say, oh, my back hurts. I had surgery 12 years ago. It's gotten a lot worse now, and I know I can't work. Won't fly. You have to have a doctor. You have to have objective testing. You have to have some means of proving to Social Security, besides your word, that you're totally disabled. The test is simple, that you are so disabled that you cannot do any job that exists in the national economy for a period that has lasted or can be expected to last 1 year. Now, most people, in the way the system works, you file an initial application. For most types of Social Security, you can do that online at socialsecurity.gov or ssa.gov. You go there, you bring up the disability application. It's a lengthy, burdensome application. It wants to know name, addresses, phone numbers, doctors, places of employment, medications, daily living. It goes on for pages and pages. A lawyer can help you with that, but you're going to have to fill out all that fundamental information. Once you do that, the process starts. It's a simple way to get it going. Effectively, if you haven't been off work for a year, Social Security is going to turn you down initially, because their test is that you have to be off work for at least a year for the process to start. A doctor can say with certain things, well, they haven't been off work a year yet, but they're going to be off work. Terminal illnesses, those kinds of things. Permanent paraplegic, quadriplegic injuries may result in you being off. So the doctor could say it in advance, but they're very rare, and typically, if you apply, they're going to turn you down for at least a year. And I'll go through that detail in a second. There's 2 fundamental means of obtaining Social Security disability, not counting children's benefits. Children's benefits are completely different. I'm not going to address them. If anyone has any questions, they can see me after or call me in my office. They're very difficult to get these days. If your child has ADD or ADHD, I can almost guarantee you're not going to get benefits for that child. I get calls every day from parents who have children with ADD. I know it's tough to deal with. I have grandchildren that have that, but it is not a disability under Social Security by itself. It can be if it's really extreme. So besides the children's benefits, there's Social Security disability, SSDI, it's called Title II. That's regular disability for people who have been employed. Fundamentally, Social Security says you have to have worked 20 out of the last 40 quarters or 5 out of the last 10 years. So you have to be a working person in order to get regular disability. It's an insurance policy. You have to pay into the system in order to get the benefits. Just like if you have a private disability policy, if you don't pay the premium, you don't get the benefit. Same thing with Social Security. If, however, you don't meet that requirement, there is something for people with no assets and who have not worked. It's called Supplemental Security Income, SSI, Title 16. SSI is not regular Social Security disability. People confuse the two all the time. SSI is a welfare-based program. You can have no more than $2,000 in the bank. You can have no assets. You can have virtually no money coming in. meaning you're destitute and this is all you're going to get, the maximum benefit under SSI is $700 a month. The benefit under Title II or regular Social Security disability is about $2,300 depending on your income, and there's an averaging, and if you're making maximum over a course of 5 years, it goes up to about that plus 50% of that for any of your family dependents. So you could get in the mid 3,000s depending on how big your family is and what your income level was. The other big difference between SSI and SSDI or Social Security Disability is if you get on Social Security Disability, the regular disability program, 29 months after the date Social Security finds you disabled, you're eligible for Medicare. So you'd have full Medicare just as if you had retired at age 65 or 66. Full insurance benefits there. You pay the premium, but you would have the benefit. SSI, you are not eligible for Medicare. You would get the state program of Medicaid, again, the welfare-based health insurance program. Your benefits are limited, but they're certainly better than nothing. SSI, Medicaid, and that starts right away, by the way. And Social Security Disability, it's Medicare, and it's 29 months later. The reason it's 29 months is if you are working and you go off work on COBRA, the initial COBRA period is 18 months. If you're disabled, they extend it for another 11, hence the 29 that Medicare picks up. So how do they get there? How do they determine that you're disabled? As I told you, first question is there any objective medical evidence of your problem, not just your word or your cousin's word that you don't feel good? So they're going to look to see if you're performing any substantial gainful activity. Basically, in their lingo, that means are you working? They tell you, and this is a big caution, if you go into the office or you call on the 800 number, and by the way, I've been at national conferences, the people who run the Social Security Administration, and they have admitted that the 800 number gives out bad information. So I don't know what to tell you from there, but they do. And people come into my office all the time saying, oh, I just called Social Security and they told me. And I have to say, okay, but they're wrong. That's just not the answer. And here's one of the things they tell you all the time. Yes, you can work, but if you earn under $1,000 a month, then you're eligible, that's the word they use, for Social Security Disability. So people say, okay, well, I've got this really terrible disease, but I'm dragging myself in and I'm working and I'm only earning $1,000 a month, and that's certainly not going to go very far with my family of four, but at least it keeps us off the street. Then they apply for Social Security Disability. And Social Security says, well, we notice you're earning $980 a month. If you worked another 5 minutes a day, you would be over the $1,000 threshold, hence you're not disabled. So the bottom line is if you're applying for Social Security Disability, you cannot be working at any job, at any income level. Otherwise, you're going to get denied. I mean, it's really that straightforward. Now, there are probably exceptions to that, but they're very, very limited. So if you came into my office and asked me, I'd have to tell you cannot be working for at least a year. After the first year, once you meet that threshold, it is possible for some limited part-time employment. They allow you to do that. It could be sheltered kind of employment. You could work for your uncle who allows you to lay down when your back's killing you. You don't have to go in on a regular basis. Maybe you work from home, doing selling eBay for your neighbors. There are things you can do after that first year. The first year you can't work at all, no matter what Social Security tells you. The next test is, do you have this severe impairment? Again, objective medical evidence. In order to make it uniform throughout the country, Social Security has attempted to put together listings of impairments. So they take what are typical illnesses or injuries, they come up with a definition, and theoretically, if you meet the definition, then they say, okay, you're disabled. It doesn't work that way. Let me just give you an easy one. The low back, you would think that's easy to diagnose. It says you have to have evidence of nerve root compression, a couple other things, lumbar spinal stenosis, herniated disc, all things you may have heard of. Doctors easily diagnose them. I have clients that walk in with those diagnoses, meets the listing 104. They say, no, we don't believe it. So it doesn't matter. We just have to keep going. If you meet a listing, and there's some things that will do it, COPD, lung problems, if you have a pulmonary test and they come up with these numbers, it's hard for them to argue you don't meet the listing, so they will grant the benefit. There are other means they do it, but they've broken it down to 14 various sections based on body parts, musculoskeletal, cardiac, and so forth, mental. And if you meet the listing, then you can get benefits at that level. If you don't meet the listing, then they go further and they want to know if there's any vocational relevant work you can perform even with your disability. I mean, there's plenty of people that have the things that are listed in this book that are able to work. May not be as severe as your particular impairment. So there's a process, and I don't really have enough time to go through the whole process. Basically, they look at your age, your experience, your training, your education, and see if you have any job skills that can move from what you were doing to something else. I get all the time, I'm a 44-year-old iron worker, I hurt my back, I can't go back to work as an iron worker, can I get disability? No. The test is you can't do any work that exists in the national economy. Any work. Take tickets in a movie theater, make change at a gas station, be a hostess at a restaurant. An iron worker with a bad back, perhaps, could do those kinds of jobs. Hence, they don't meet the test for disability. They then break it down. I don't think we need to go through that because I want to give you the process and how long it takes so you know. The first step, as I said, is file the application. There are lawyers that can help you. I don't think there's many in this town that do initial apps. We do because you have to do so much of the work, but we'd like to bring you in and go through the application to make sure we give as much information as possible to the administration. The initial applications are taking 4 to 6 months, and they'd turn down the majority of them. The next step is what's called reconsideration. It's a paper appeal. It basically says, you're wrong, we're right. You have to relook at it, and here's some more medical evidence. If you didn't read it the first time, here's more of it. Those are taking 6 to 12 months. Nationwide, I think they're turning down about 85% of them. So looking at the longest periods, we're already up to 18 months from the date you applied, and in some cases, you may have been off work a year already. We then request a hearing in front of an administrative law judge. That's currently taking 8 to 12 months to get a hearing date here. We win an overwhelming majority of those cases, but you could be up to 3 years. That's why I say there aren't many fakers in the system. You have to be real dedicated to be off work for 3 years, having no income, and the hopes that you're going to get some minimal benefit from Social Security at the end. Assuming you lose at the administrative law judge level, the law used to be better. They've just changed it, and it's made it very difficult. It used to be we could, again, do a paper appeal to the appeals council. We would write a brief appealing it, and the judges, in fairness to them, it's very difficult to comply with all the requirements to get a coherent decision. They may not believe the client, but they have to cover all the bases. It left us a lot of room to appeal. The judges here are very good. Judges around the country are not. Our judges, although I don't always agree with them, are professional, respectful. They run, I think, a fair, impartial hearing. That doesn't mean, of course, we win all our cases, but at least you're treated with respect. I can't, unfortunately, say that about all the judges across the country. In any event, if we do, it used to be if we lost, we could go to the appeals council. It's a brief, but at the same time, we could have our clients file a new application. So if we have new medical evidence and we could start the process again, now they won't let you do that. It's either or. Appeals council takes 18 months. Could be quicker, but, and if you lose there, then you can go to federal district court. It takes about a year. So there are legitimately claims that have gone 5 years or longer. And those time frames I just gave you are longer in other parts of the country than they are here. So, I mean, we can be successful, and all those can be shorter. You can get benefits quicker than those time frames I gave you. It happens. I tell my clients it's sort of like winning the lottery. I've had people who have had cancer so bad of the abdomen that their internal organs are outside and they've lost. I've had clients on the list for a heart transplant. They have not lost eventually, lost for the first 2 stages. In front of a judge, we've won. But so I can't tell you, you walk into my office, my doctor said I'm disabled, I have all this medical evidence, this is a slam dunk, right? Nope. We'll go through it, we'll move it as fast as we can, but you need to know you have to make arrangements with friends, family, church, synagogue, Clark County Social Services. You're going to have to live for a couple of years without any income. So it's not a happy story. It's a happy story at the end when we finally get you on benefits, because then you're on for the rest of your life or until you improve. So that's sort of it in a nutshell. I have a small amount of time. It's a very detailed process. I guess my last bit of advice to you is if you go to someone to help you with this, make sure that they know what they're doing, that they've been doing it for a while and they're familiar with the system. It is a very specialized area of the law. A generalist can't do this kind of work. I might be able to write a simple will, do a simple contract. I wouldn't go any further than that, but for sure you need to know what's going on because it's its own little segment. So happy to answer any questions. Sorry it had to be so quick.
Okay, the question is, I have a Social Security hearing tomorrow. What will happen?
Okay, assuming it's with the judge, not a reconsideration face-to-face hearing. One, if you have a case, I suggest you ask the judge for a continuance so you can get counsel. Absent that, the judge will ask you a series of questions trying to determine whether you're disabled. He will frankly first try to ask you to get counsel. They don't like having claimants there without counsel because we can help speed up the process and give them what they need. But if all that won't happen, they're going to ask you a series of questions. There may be a vocational expert there who will testify as to your job experience and will answer hypothetical questions. There could be a medical examiner there, a doctor, who will answer questions about, probably on the phone, but would answer questions about your medical condition.
How often does Social Security evaluate people on SSDI?
Well, they say they're going to, sometimes you'll get a notice after you get it that they're going to review you in a year. Last I knew, there were 1 million to 1.5 million cases behind on those continuing disability reviews. So, again, there's no rhyme or reason that we can determine as to who they review and who they don't. So I can't give you an answer to that. You may never get reviewed. It's not a regular thing. They don't review you every 3 years. They don't have the staff to do that.
Can you draw a pension and still qualify for Social Security disability?
Yeah, sure. The only exception to that is if you're a state employee, at least in this state, you've paid into PERS as a police officer, a teacher, or state worker. So you've been paying into PERS rather than the Social Security Administration. So you don't get Social Security. You get PERS, both for disability retirement or retirement.
Have you ever successfully represented a gambler in a Social Security claim, a professional gambler?
Not a problem as long as they have paid Social Security taxes, then we can get regular Social Security. I actually have a client who's a poor retired gambler, not a very successful one, so he's applying for SSI, but that has been his occupation for the last 5 or 6 years, but because he didn't pay into the system, then all we can get him is SSI, and the advantage is that we've pretty much proven that he does really not have transferable job skills as a professional gambler, so that will help in that proof.
All right, everyone, please join me in thanking Mr. Welt for a very nice presentation on Social Security disability. We'll take a 5-minute break now to 7:25. Please come back. Hello, I'm Larry Springberg, your host for the People's Law School. I'm also a lawyer specializing in accident and medical malpractice cases. The presentation you're watching is one of a multi-session series on the legal topics which affect the daily lives of Nevadans like you. As a member of our home viewing audience, you too can earn a diploma from the People's Law School and receive the course handbook free of charge. To receive a diploma and handbook, simply send us your name, address, and telephone number stating which sessions you have watched, and the information will be mailed to you. Mail your request to the People's Law School, 406 North Nevada Street, Carson City, Nevada, 89703, or call 775-885-7174. The supply of printed course material is limited, so don't delay. We welcome your feedback. The People's Law School is for you, the citizens of Nevada. So let us hear from you. All right, I'd like to introduce now our two speakers on workers' compensation law in Nevada. George Bochanis practices law in Las Vegas. He specializes in personal injury and wrongful death, workers' compensation, products liability, and premises liability. He received his Juris Doctorate from Pepperdine University in 1982 and was admitted to the Nevada State Bar in 1982 also. He was the president of the Nevada Justice Association in 1995 and serves as a speaker for 2005. Thank you. And serves as a speaker for continuing legal education seminars sponsored by the Clark County Bar Association, Nevada Judges Association, and the Nevada Justice Association regarding Nevada personal injury and workers' compensation law. He has been involved in over 30 jury and bench trials, tried to verdict in the 8th Judicial District Court and Las Vegas Justice Courts, and has represented plaintiffs in over 300 arbitration cases to conclusion as part of the Nevada Mandatory Arbitration Program. Brian Nettles is the owner and founder of the Nettles Law Firm. He was born in Phoenix, Arizona, and has been a Las Vegas resident since 1984. He received his Bachelor of Science degree in Hotel Administration from UNLV and attended the University of Dayton, where he received his Juris Doctorate in 2000. Brian was admitted to the State Bar of Nevada in 2000 and the Bar of the United States District Court, District of Nevada, in 2005. Brian Nettles has been honored as a top 100 trial lawyer by the American Trial Lawyers Association in 2009, 2010, and 2011. And he is currently one of 2 Nevada members of the American Association for Justices Board of Governors. For more than a decade, Brian Nettles has been dedicated to helping victims and their families in the areas of civil litigation, personal injury, workers' compensation, and products liability law. His community involvement includes Families for the Effective Autism Treatment, Habitat for Humanity, and Toys for Tots. Please join me in welcoming George Bochanis and Brian Nettles.
Fancy seeing you. Very nice seeing you tonight. Anyway, good evening. I'm George Bochanis, my co-presenter Brian Nettles to my right, and we're here to give you a short presentation on Nevada worker compensation law as just a preamble to what we're going to talk about tonight. Nevada worker compensation law is a very unique and distinct kind of animal. It's based on a very specific set of Nevada statutes that have been modified and enhanced and subtracted and added to by our Nevada Supreme Court for the last 50 to 60 years. And so Nevada, it's really interesting to talk to other people in other states that have had worker compensation cases in California or Arizona or Utah, and to listen to their experiences and then to tell them how Nevada worker compensation law works, and it's typically a night and day scenario. And so Nevada, like I said, Nevada worker compensation laws are very, very unique and specific to Nevada. So if you have an uncle that has a work injury in California, don't base anything that you've heard on what he's told you, because none of it applies in Nevada.
Yeah, we deal with fighting preconceived notions every day. Being that you're in Nevada, when you're hurt, you're probably going to have a much more difficult time than your friends and family members from across the country. So I think we spend a lot of our time talking people down, saying, hey, that you're not going to get what those folks got. You're going to have to dig in and get ready for a battle. It's a very, very difficult system. And George and I are tasked with talking to you in about the next 20, 25 minutes about this system, so you're only going to get the real basics this evening.
So part of our materials tonight are some handouts that we have regarding Nevada worker compensation information, it's called. These forms, just to let you know, are very generic, very general, and Nevada worker compensation law involves really a lot of very detailed, arcane types of rules and laws regarding different types of things. But the handouts, for the most part, provide you with just a very basic understanding, general background on some of our laws. The first thing that we talk about is to have an injury become a worker compensation claim. It has to be called, and the operative phrase in Nevada is, in the course and scope of employment. And that's the operative phrase for something to occur where it's going to be compensable, is what the other term of art is, under our Nevada worker compensation laws. And if you're going to have an injury on the job, the most important thing right off the offset and right off the start is you have to report it. And Nevada has very strict timelines, unlike other states, that you typically have to report it within 7 days of it occurring. So, as an example, you pick up a box, feel a problem with your back, and you wait 14 days and you tell your employer about it, you're going to have a worker compensation claim that's going to be denied by the employer.
Right. What you're going to see over these next few sections is the time guidelines are very difficult and very strict on injured workers. As George was just talking about, the first number that you run into is 7 days to report that injury to your employer. Although we can caution you all night long as to if you wait until that 7th day to report an injury, you're still in for a big, big battle. Certainly, it is always best to put your employer, your supervisor on notice as soon as an injury happens. I mean, even waiting till the next day or 2 days later, you're looking at causing yourself trouble and grief when the employer or the insurance company or the work comp administrator comes in and denies your claim as saying they don't believe that it really occurred in the course and scope of your employment.
And that's a great point, because despite the fact that there is this strict timeline, as I stated earlier, that's just a general timeline. That could still be affected by other things, such as you injure your back and you don't report it yet to the employer, and a day later you're fired from your job for other reasons. The following day you report your injury to your employer, well, that 7-day rule doesn't apply anymore. Now there's a presumption against you from injuring yourself on the job because you were fired before you reported your claim. So it's just a perfect example of how we like to say Nevada worker compensation laws aren't exactly employee friendly.
Not exactly. No, it's a very difficult system. We see lots of folks, lots of clients who come to us who had the belief that they were trying to do the right thing. They said, gosh, I felt some pain. I thought I'd go home and sleep it off, and I waited a few days, and I finally got into my own doctor, and it took 10 days just to get the appointment and get in, and he confirmed that I've a blown disc in my back or in my neck, and it all happened at work. Well, those people unfortunately are going to be barred because they didn't follow the reporting requirements. So I'd suggest to all of you that you take the opposite tact, and if there is a doubt, go ahead and report it. Maybe it won't ever grow into anything, but if you at least let your boss know that something's occurred.
And it's a perfect example of how our worker compensation laws are very skewed against the injured worker, at least in my opinion, and with the way a lot of these things are interpreted, which is why it goes counterintuitive to a lot of people, and I think a lot of the clients that we see in our respective offices that typically do want to wait and see things get better and don't want to make a big deal about it, don't want to upset the supervisor. I've worked for the same company for 15 years, I love them, and what happens is they end up hurting themselves, they wait, they're barred, and they have a bad back, and they have a lot of problems getting treatment or care for it. So it becomes a real issue.
So the next time guideline that you're going to run into in the materials is you need to fill out a C4 form. The physician that you see, when you tell the physician, whether it's at an emergency room or your chiropractor or your family doctor, that you've had an injury at work, the physician is to provide you with a C4 form. The injured worker is to fill out the top half of the C4 form, and the physician fills out the bottom half. you have 30 days to get this completed, and the physician has 3 days once you filled out your portion to complete his or her portion and forward that on to the employer and the insurance company. But again, I would caution you, like I do all the people that I speak to and my own clients, it's never good to wait the 30 days. If you're feeling some pain, you want to get in and get checked out, number one, to make sure that you're okay. And number two, the closer you are in time to the injury, the better chance that the doctor is going to have to tie the injury to your industrial event.
So the next thing we should probably talk about is medical treatment. So you pick up that box, your back starts bothering you, and you say to yourself, okay, I'm going to report it to my employer. You do within 7 days. And then you say to yourself, well, I'm going to look through the phone book or go to the internet or go to my general practice doctor down the street and have him take care of me for this work-related injury. Seems simple enough. He'll make sure I get the care I needed. And Brian, how does that usually work out for you?
That usually shoots the worker in the behind again. You're going to find out from your employer either who the list of doctors are or who you should go see at least initially, or find out who the work comp insurance carrier or third-party administrator for your company is to find out what doctor you should see. You're going to be directed to one of their doctors, one of their clinics in the beginning, and then subsequently you're going to have to treat with a list of providers that they provide to you, although there's some leeway, at least in the beginning and again with certain time frames, in choosing which physician that you want to see off of that list.
So Nevada worker compensation medical treatment is usually done through your employer's, not yours, your employer's managed care physician panel. So it's a group of physicians that your employer decides that are going to be appropriate for your worker compensation care. So with that in mind, I just wonder what kind of requirements, what kind of system that the employer would use to put doctors on a closed panel list that only injured workers at their place of work could use. What kind of doctors would those be,
You
Brian?
sound very biased right now, Mr. Bochanis. So, as you can see, I mean, it's a difficult path that injured workers face in this state. The employer, like George just said, the employer or the insurance company chooses the physicians on their list, and those are the only physicians that you're going to be entitled to see. So hopefully you can navigate your way through that list and pick out, some of the best physicians, or the better physicians who are on the list.
And on that note, let me just wax nostalgic for a second, because this is a relatively new system that we have in Nevada as far as managed care for worker compensation medical treatment. It wasn't until we had a governor in Nevada, Bob Miller, who him and the legislature decided in the mid-90s that we had a worker compensation crisis in the case in Nevada. And one of the ways of taking care of the crisis was to take the right of a worker to seek any doctor he wants for care, which is the way it used to be, and then put him onto these closed panel lists for the employers, because the poor employers, large multinational casino companies and places like that weren't earning enough. And as a result of that, going to these closed physician panel lists would save them tremendous amounts of money in getting that high quality of medical care to the injured worker.
Again, you sound biased.
Anyway.
Do you care more about the injured worker or the employers?
Well, I just want to make sure the employer, is able to save anywhere from 10 to 20 million a year that most of them have saved by this new system of physicians.
And we would throw out to you that if the injured worker gets the proper medical care early on in the treatment, in the plan, that actually would save the employers and the money that's intended that this program saves. To get an injured worker the proper care and treatment and get them back to work immediately is the goal of the system. It's the goal of us as workers' compensation claimant attorneys. We want to get our clients, we want to get workers back to work, and that's what the vast majority of our clients and injured workers want. They just want to get better, and they want to get back to their jobs and get back to their lives.
So if you miss time off from work as a result of a work injury, what you receive is something called temporary total disability. This is, I Again, another a very specific worker compensation statute in Nevada where a person that misses time off from work because of his work injury receives a percentage, not 100%, but a percentage of his income that he earned with that employer over a certain time period before the actual work injury occurred. And Brian, I'm assuming that also is very, very, the employer is very open and easy as far as determining what that rate of pay would be.
Right. Well, what happens is typically this goes to the insurance company or the administrator, and it becomes a battle for the injured worker to actually determine what his correct average monthly wages are. It's especially a problem in this state where we have lots of workers who work for tips. We have lots of workers who are in tip compliance programs with the federal government. So the average monthly wage that's calculated is going to be based on what the worker makes on paper. So that causes the first problem. Second problem is that there's a state maximum wage. That wage is adjusted, I believe, annually. And I think right now it's a little less than $6,000 a year. So if you have a worker, or I'm sorry, $6,000 a month. So if you have a worker who's earning in excess of that, they lower the rate down to the state maximum, and then you determine your benefits from there. Now, the TTD benefits, or the total temporary benefits, or what we call the paycheck style benefits, only pay you 2/3 of what you were making, again, up to the maximum, although that money is tax-free. But certainly it leaves injured workers in a distressed spot, in a much worse spot than they would have been if they were able to continue on with the normal work weeks.
Which is why typically we see most people that are involved in a worker compensation case try to avoid going off of work if they can, because they're taking a huge financial loss from doing this, which again motivates them, and we think that which is a great idea, to follow through with their treatment promptly, get the care that they need so that they're able to go back to work and minimize the type of harm that this type of claim can do to you, especially financially, because not receiving your full pay after a work injury and you have to go on this TTD is a real sacrifice.
It is, and another, well, two more negatives that I think of just off the top of my head is injured workers only entitled to the TTD benefits if they're off 5 days consecutively or longer within a 20-day period. So if an injured worker is taken off for 2, 3, 4 days, they get no pay for those days. Or if they have to miss 1 day because they have doctor appointments that day, injured workers don't get paid for that time. So it really is a financial strap to injured workers. There was one other thing that I thought was really bad too.
And what was that?
I would like to know what that is myself.
Okay.
It's tough getting old. You wouldn't understand.
Yeah, I wouldn't. Yeah.
So, two bad things to TTD: that the 5 days and.
Didn't someone do this with the departments they wanted to eliminate during the presidential
Oh,
elections?
I'm sorry. Yeah. You know, the other thing I was thinking of, if the doctor says that you're on limited, that you have ability to work, but you have limited abilities, so the doctor might say the injured worker can only sit or stand for so long, or can only lift up so much weight. Then shifts to the employer to determine whether they can comply with those work restrictions. If the employer chooses not to comply with those work restrictions, then the injured worker would get the TTD benefits again after the 5th day. If the injured worker's employer decides we will comply with those benefits, the employer has the right to not pay the injured worker 100% for their time while they're working in the modified duty. They can drop that rate down to 80% of what the injured worker's normal rate is. So again, you're really creating a financial hardship for many injured workers in this state.
So
I knew it would come to me.
Yeah, exactly. And so the question that when a client comes and sees me about a worker compensation case, and invariably we get to the question is there a settlement? Do I get some type of settlement at the end of my case because of my pain and suffering, or because of all the time I had off from work, or my sleepless nights, or all the doctor visits I had as a result of this worker compensation case? And my answer to them is not really. You have something what's called permanent partial disability, And that's the type of award, I guess, that you would receive at the end. And the award isn't based on your pain, it isn't based on your suffering, it isn't based on the amount of your lost income. All those things that you heard earlier this evening about a personal injury case and all the factors that go into how a person's compensated for that type of a harm, they don't apply to worker compensation cases. Instead, we have a whole different system for what's called a permanent partial disability. Brian?
Well, I'm gonna sort of back up and tell you all how you get to that point first. First, the claim's open and accepted. We talked about seeing the medical doctors. Once a physician releases the injured worker from care, he decides that he or she decides that the injured worker is stable. And what the term stable means under the work comp context, the work comp medical context, is that the physician doesn't believe that the injured worker is going to get substantially better or worse for the next 6 to 12 months. So that's when the worker is released from medical care. The second question that's posed to the treating physician is, well, is the worker rateable? Does the worker have a rateable impairment? And what that means is, does the doctor believe that that worker will fit within the American Medical Association's guidelines to permanent impairment? And when we say that, we don't mean disabled. We don't mean necessarily that the worker can't work anymore, but maybe they can't bend or twist anymore, or maybe they have loss of range of motion in their shoulder or their neck or their back. So lots of different things. So if the doctor decides that, yes, his or her patient is rateable, then the work comp insurer, administrator, or employer has the duty to set the injured worker up for a permanent partial disability evaluation. The worker is sent to a doctor that he or she has never seen before. The doctor's provided with the medical records and then also sees the worker for a physical examination and determines where that worker fits into the American Medical Association's guidelines for permanent impairment. It's a big, ugly green book that we know very well, where the worker fits into there and puts a percentage of impairment on the worker. That percentage of impairment is going to be key to what the worker receives as a settlement. You want to talk about what the other factors are?
Sure, and a really big question I always get asked is, well, how is this doctor chosen and where does he come from? And what happens is, there's a huge list somewhere secreted away where doctors go to a course, and it could be a OBGYN, it could be a orthopedic surgeon, it could be a chiropractic physician. Any licensed medical physician in the state of Nevada can apply to be a rating physician under our worker compensation laws. And what happens is these doctors are all on the list, and what essentially they do is they take a course where they become proficient in that, you call it ugly green book?
The big, ugly green book.
It is an ugly green book. And within that book, depending on what your injury is, whether it's your back, is it your hand? Is it an ankle? Is it a scar? Is it nerve damage? It covers the whole gambit of every possible injury you could have on a worker compensation case. And what that doctor does is reviews the AMA guidelines in that green book and applies them to his examination of that patient. And based on that examination and how that examination applies to that book and what that book says that your rating is how that percentage comes about, and that percentage is what determines what your worker compensation case is worth in a financial sense at the end of everything.
So based on the percentage of impairment, again, that number goes into a formula. That's one of 3 variables that go into the formula to determine what the injured worker is entitled to. The percentage of impairment, the worker's age, showing how long they have left to work in the system. So the younger someone is, the more time they have left in the system, typically the higher the settlement at the end. And then the last factor would be the average monthly wage. So again, how much someone's making. And when you put those 3 variables into the formula and then you do all this crazy math and Shazam, it tells you what the injured worker's entitled to resolve the workers' compensation claim.
So as an example, a 70-year-old that works for $7 an hour and is found by the rating physician to have a 1% impairment is going to receive a settlement at the end, a PPD rating at the end that's substantially less than a 27-year-old construction worker making $34 an hour, and who has a rating because of a 2-level back fusion of 20%.
Although they'll both get substantially less money than they deserve.
No, and for sure, there is nothing, there's nothing worse than seeing people go through multiple surgeries or have a loss of a limb or have extensive scarring, and you run them through what our worker compensation system provides, and when you see that number, the client always says, I can't believe how low it is, and we tell them, there's a city called Carson City in northern Nevada where people meet every 2 years, and you need to change the laws up there if you're going to make a difference on any of this. Because the way these laws are written, you're not really compensated fully for what you go through on something like this.
So we told you it was a bad system in Nevada. Very, very difficult for injured workers. Now I see we're running out of time, Larry. Do we have questions that we need to get to, or should we keep going?
You can keep going for a little.
Okay. So keeping along the lines of the PPD settlement, a lot of folks, especially that have either been here for the personal injury talks or have had their own personal injury case, they'll ask us, well, can we negotiate that settlement? Because that's typically what would happen in a personal injury case. And we tell them, no, you can't, because it's based on this formula and these variables. And there is one way to sort of appeal the PPD rating, and it's based on the percentage of impairment. We know with the other two variables, with the age and the average monthly wage, that those aren't going to change. They are what they are, assuming they were done correctly, which is something that you need to check or have your lawyer check for you. But if you believe that the rating physician did not do the rating correctly and give you the correct percentage of impairment, you can appeal that. You can get a new rating, typically at the cost of an injured worker, which is nearly $1,000, to get a new rating, under the hopes and rolling of the dice that the new rating comes in at a higher percentage, which would then typically lead to a third rating physician, because now you have the two sides arguing over which of the physicians is correct. So.
But that is the only way you're ever going to technically appeal a worker compensation PPD award, is if the rating physician misapplies the standards and guidelines within those AMA guidelines, within that AMA guidelines book. And what's really interesting, excuse me, about the AMA guidelines book too is it changes. It changes every year or two. There's different editions that come out, and as a result of the different editions, different injuries are rated for different percentages. So when I first started practicing, seems like a long, long time ago, a hernia received 1%. Subsequent editions, a hernia could be rated now 5 to 7% whole person. 10 years ago, a back discectomy was a certain percent. Now subsequent editions, what occurs now is it's a completely different percentage than it used to be. And when people, and when I try to explain this to clients, especially a client that had a case 8 or 9 years ago for a certain injury and they have something coming back and they come back and see me, and I explain to them it's an entirely different percentage now because a different edition is being used, and they ask me, well, how does that occur? And I say, that's a great question. It's just a great question.
Explaining it to our clients, I don't think we can even explain it to other attorneys. The system is...
Yeah, what happens is the AMA guidelines come out with new editions every 1 to 2 years. And what happens is the grand poobah doctors who all get together and decide what is going to be rated for what, decide on that year and for that edition that this type of an injury or this type of a problem is going to be that percentage. It is that subjective. It is that non-scientific based.
And then we wait to find out if our state legislature is going to adopt those certain additions. So although there might be additions out that are way ahead of where we're at, we are in the addition that the state legislature says that we should use. Yeah, so.
Let me go to the first question.
Sure.
Okay.
Gosh, Larry, we had so much more happy things to discuss with our
Well, here,
audience today.
this is a very good question. What factors go into determining whether or not an injured worker is going to be offered vocational rehabilitation training?
Larry, there are no good questions, only good answers.
Go for it.
That's why I have to turn it over to George.
Do you want me to do that one?
Go ahead, sure. I'll jump in and fix it. Go ahead.
Okay, that's fine. Vocational rehabilitation is when you are not able to return back to the type of job that you had based on the type of tasks, physical tasks, that job required. And as a result of your work-related injury, what happens is you're unable to return to that job, and your employer doesn't have a job to provide you with your new job restrictions.
Permanent.
Whether they be lifting, standing, it all depends on the job and the job duties. And so that's when vocational rehabilitation kicks in. And you are then assigned a vocational rehabilitation counselor that you have no choice over whatsoever. I'm sorry.
biased again.
Sorry, I'm being that way again. And that person tries to work with you to go through a lengthy process where you sometimes get retrained and you sometimes don't get retrained, depending on what occurs. You can seek a buyout, a cash buyout, instead of getting retrained if you get that far. But
you have to be careful of that because there's a lot that comes along with it. You all have to understand we're just touching on the tip of the iceberg tonight, so I'm sorry to interrupt.
oh no, that's there are another 20 to 30 issues on vocational rehabilitation that you have to be aware of. Because if you don't, you're giving up a lot of rights. And you know, I have to tell you what, that applies to everything on worker compensation.
Right.
If you don't know every little corner, if you don't know every little subsection of a certain statute, you're not going to be, it's not going to be explained to you. You're not going to be told about it, and you're going to lose that benefit. So I always tell clients to be wary in navigating these types of waters because they're really rocky. And there's a lot of bad things in it. So vocational rehabilitation is a perfect example of that.
And oftentimes when an injured worker comes to us for help, it's too late even for us to jump in and help because of all the time guidelines. And whether that's getting the claim accepted or getting the proper medical care, getting the paycheck style benefits, the PPD, or the voc rehab. I mean, every little thing has its own time guidelines and all the hoops that the injured worker has to jump through, so it's very, very difficult.
Do you find that Nevada's workers' compensation laws sometimes discourage injured
I'm sorry.
workers
Sorry. What was the
from
rest of that? I'm sorry.
filing a workers' compensation claim or continuing in a filed workers' compensation claim?
I think that unfortunately injured workers get very discouraged, whether it's before they file or during the claim, to where a lot of injured workers abandon their claims and just learn to deal with the pain and suffering and injuries that they have as opposed to pursuing the claim. Yes.
And my answer would be yes.
Okay.
You said it so much more succinctly.
And here, and this is actually a very specific vocational rehabilitation training question. What happens when you take the buyout and get injured again?
Brian?
Well, it's gonna, it's going to affect
That's
not
what you were
only,
saying about buyout.
yeah, not only
Yeah.
if you're injured again, but in workers' compensation, you also typically have lifetime reopening rights. So if someone has a significant injury, case goes all the way to the case closing, you then have lifetime reopening rights. Now, again, with a big asterisk and a big but, very difficult to reopen, and there's certain time guidelines that make it more and less difficult. But if the case were to be reopened, or if a worker had a new injury, they're not, number one, they're not going to be entitled typically. I don't know that there's any, when our co-speaker, Kathleen England, said the answer was, it depends. That's the answer to most of the questions that we get as lawyers. And this is a big it depends question, but typically you're not going to be entitled to another program.
All right, well, on behalf of the Nevada Foundation for Consumer Education, I'd like to thank you, George.
Thank you.
Thank you. Certificate, and
Thanks.
Brian,
Thank
thank
you,
you both. I'd like to remind everyone to turn in their speaker evaluations on their way out, and I look forward to seeing you next Tuesday. Thank you again.
Thank you all.
Thank you.